Hello, my name is Luke Flynn, and this video is designed to help parents and guardians better understand the history of special education law in the United States. Knowing these laws empowers families to advocate for their children and to work collaboratively with schools to ensure students receive the supports and services they are legally entitled to. History of special education before the 1970s. Before the 1970s, students with disabilities were often excluded from public schools altogether or placed in segregated settings without meaningful instruction. At that time, there were no federal laws requiring schools to educate students with disabilities. Many families had little legal recourse if their child was denied access to education. This began to change as parents challenged school systems throughout the courts, arguing that denying education to children with disabilities violated constitutional rights to equal protection. History of special education from the 1970s to present. A major turning point occurred in the early 1970s with landmark court decisions that affirmed students with disabilities have a right to public education. These cases laid the foundation for federal legislation, including the Education for All Handicapped Children Act of 1975, now known as the Individuals with Disabilities Education Act, administered through the U.S. Department of Education. IDEA guarantees students a free, appropriate public education, access to individualized instruction through an IEP education in the least restrictive environment, and procedural safeguards for families. These protections continue to evolve through reauthorizations and court interpretations. Key court cases on parental and student rights. One landmark case is Board of Education v. Rowley, 1982. This case clarified that schools must provide meaningful educational benefits, but not necessarily the best possible education. For parents, this case underscores the importance of understanding how progress is measured within an IEP. Another significant case is Andrew F. v. Douglas County School District of 2017. This decision raised expectations for educational benefit by requiring schools to provide programs that are appropriately ambitious in light of a child's circumstances. This ruling strengthened parents' ability to advocate for more individualized and effective services. Together, these cases reinforce that parents are essential partners in educational decision-making and that schools must be responsive to individual student needs. Legal trend resources for parents. To stay informed about current special education laws and protections, parents are encouraged to use the following trusted resources: the U.S. Department of Education, which provides federal guidance on IDEA and FERPA, the Office of Special Education Programs, offering updates on policy and compliance, the Rights Law, a family-friendly resource explaining special education law and advocacy, the Arizona Department of Education Exceptional Student Services, which offers Arizona-specific guidance, dispute resolution options, and parent supports. Closing. Understanding special education law helps parents become confident advocates for their children. These laws exist to protect student rights and ensure access to meaningful educational opportunities. Families are encouraged to ask questions, stay informed, and work collaboratively with educators to support student success. Thank you for taking the time to learn more about special education law.